Good morning, good afternoon, good evening, depending on your time and depending on when you're going to be seeing this video. It's your brother, your boy, courserepscorner. Like I always tell you guys, it's my corner, it's your corner, and it's our corner.
I don't wanna fall in love. I just wanna have some fun, yeah. I don't wanna fall in love.
Call and providing for us a platform to air our views and our opinions. In a democracy, freedom of expression and access to the media are fundamental pillars and are indeed the very basic reason why countries and peoples subscribe to democracy all over the world. This is a press conference by the Forum for Accountability and Good Leadership on the injunction granted in the Isu Njaba Nkwere Nwangele Federal Constituency election. That injunction was granted by Justice bciheka of the Imo State High Court. The Forum for Accountability and Good Leadership is a registered organization with the main focus on issues that promote accountability and good leadership, and we frown at issues of abuse of power, impunity in public office, corruption in all its forms, and other vices which impede the development of our dear country. We do this mainly for the interest of justice and protection of the sanctity of the judiciary in cases like this. Sometime last month, our attention was drawn to an ex parte order granted by one Honorable Justice bciheka of the Imo State High Court, stopping the election process and declaration of a final winner in the 25th of February 2023 election for the seat of member representing Isu Njaba Nkwere Nwangele Federal Constituency. This is probably the only ex parte injunction given in the entire Nigeria stopping an election process in these 2023 general elections. As of date, we have not been notified of any other such injunction. We shall make a copy of the certified true copy of the said ex parte order of the court available to you. The said ex parte order was granted in suit number HOW 274-2023. The parties to the suit are Barrister Harrison Wadike, who was the plaintiff, and Professor Mrs. Rosetta Okechukwu, the defendant. Just two people. Barrister Harrison Wadike, the plaintiff, and Mrs. Okechukwu Rosetta, the defendant. The said plaintiff is also the candidate of the All Progressives Congress, APC, for the said election. That's the Isu Njaba Nkwere Nwangele Federal Constituency. Is the candidate of APC for the said election, while the defendant, Professor Mrs. Rosetta Okechukwu, is the person appointed by INEC and posted as the returning officer for the said election in that federal constituency. From the contents of the writ of summons filed before the court, the subject matter of the ex parte order shows that it borders on substantial issues of holding an election conducted by INEC. Despite the unambiguous provisions of the Constitution and the Electoral Act, Honorable Justice bciheka proceeded to assume jurisdiction, grant all the prayers in the writ of summons at ex parte, and as you will hear, he also took other steps to frustrate the conduct of elections and declaration of results in the federal constituency. As of today, the 19th of April 2023, almost 2 months after the election, there is yet to be a declaration of a winner or not in that federal constituency. The said motion ex parte was moved and granted on the 27th day of March 2023. The express words of the ex parte order forbid the returning officer, that is Professor Mrs. Rosetta Okechukwu, or the returning officer for the said election, Professor Mrs. Rosetta Okechukwu, or any other person who is appointed by INEC to announce, it forbids them from announcing the winner of the said election pending the holding of elections in 133 polling units of the Njamba local government area of Imo State. How the court came to determine that there were 133 polling units where elections were not held or ought to hold is still a mystery. It is pertinent to note that the holding or non-holding of elections is the primary duty of INEC as enshrined in Section 153(1)(f) and paragraph 15A of Part 1 of the third schedule of the 1999 Constitution of the Federal Republic of Nigeria as amended. The holding of an election and the processes included therein, that is, voting at the polling units, collation of results, and announcement or return of election winners cannot be interfered with by any court. This is provided for in Section 84 sub 15 of the 2022 Electoral Act. The jurisdiction of the courts can only be activated after the election is over and a winner is announced or returned. Section 285 of the 1999 Constitution of the Federal Republic of Nigeria is also explicit on this. Sections 130, 133, and 134 of the 2022 Electoral Act also made ample provisions on when the court can intervene in an election process. As a judicial officer of the Federal Republic of Nigeria, Honorable Justice bciheka is obviously aware of the foregoing provisions of the Nigerian Constitution and the Electoral Act when he assumed jurisdiction and granted the said ex parte order. Like we said earlier, Honorable Justice bciheka did not stop us assuming jurisdiction in a federal electoral matter. He also granted the main reliefs sought by the plaintiff in the main suit, which is the writ of summons. He granted all of them at ex parte level. And a careful perusal of paragraph 13A and 13B of the plaintiff's statement of claim will show all the reliefs. He actually sought for 2 reliefs in his writ of summons, and both reliefs were granted at ex parte. And for the benefit of those who do not understand these legal languages, at ex parte, the other party is not heard. The other party is not listened to. And you cannot, at ex parte, get what you took to court because you have not heard the other party. But Justice bciheka granted the prayers of the plaintiff at ex parte. Our opinion on the interpretation of this act by Honorable Justice bciheka will be left to the National Judicial Council to make, as the Board of Trustees of the Forum have submitted the petition to the Council to determine as appropriate the dance steps that will be proper for the tune currently being played by Justice bciheka. While on his journey to make this ex parte order, Honorable Justice bciheka cannot deny the fact that it did not occur to him that the election complained of is an election being conducted by the Independent National Electoral Commission, INEC. The defendant before him is an agent of INEC, a known federal agency, and that he cannot effectively adjudicate on the matter without directing that the plaintiff should put INEC as a commission on notice. Rather, he ignored the warning signs and decided to jump into the murky arena of political vamvoom contrived by a political plaintiff. The contents of the writ of summons are clear and unambiguous. Section 251, sub P and R of the 1999 Constitution of the Federal Republic of Nigeria as amended made it obvious that state high courts cannot assume jurisdiction over issues that concern INEC and the conduct of elections. Honorable Justice bciheka was fully aware of the letter when he proceeded to grant the ex parte order without jurisdiction. Gentlemen, the story goes further. On Wednesday, the 5th of April 2023, when parties were told to come for the hearing of the motion on notice, Honorable Justice bciheka failed to list the matter in the course list for the day's business. When the Senior Advocate Counsel for the People's Democratic Party, who had filed a motion for joinder, inquired of his lordship why the matter was not listed, Honorable Justice bciheka replied that he has transferred the matter back to the Chief Judge of Imo State for reassignment. It will interest you further, gentlemen, to know that on the 14th day of April, when an application for issuance of certified true copies of the processes filed in the suit HOW 274/2023 was made to the registrar of the court and was approved, the said file was nowhere to be found. Staff of the court registry said the file is with Honorable Justice bciheka on record. Staff of the Imo State Chief Judge said they have no records that the file has been sent back to the office of the Chief Judge. Honorable Justice bciheka's clerk was unable to show record of the office where he transferred the said file to. Gentlemen, the file just disappeared. But we can promise you, now that we are in this matter, the NJC will find that file and it will reappear. We strongly believe that the disappearance of the file is to ensure that the ex parte order made is not vacated quickly. This goes to the root of the second prayer of the plaintiff in the writ of summons, which is for a perpetual injunction restraining INEC from announcing the results of the election. In the midst of all this, Honorable Justice bciheka is aware he has been sworn in as a member of the 2023 Election Petition Tribunal and will not be available to adjudicate on an election matter where time is of essence. He still assumed jurisdiction, took over the matter, gave an ex parte injunction, and the file disappeared in his possession. As of today, the 19th of April 2023, that file has still not been found. By the foregoing, it is obvious Honorable Justice bciheka failed in his duty as a judicial officer to uphold the Constitution and the laws of Nigeria, and in the circumstance did not abide to the following provisions of the Code of Conduct for Judicial Officers of the Federal Republic of Nigeria. Rule 1.3, it provides a judicial officer should respect and comply with the laws of the land and should conduct himself at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Rule 3.1 provides that a judicial officer should be true and faithful to the Constitution and the law, uphold the cause of justice by abiding with the provisions of the Constitution and the law, and should acquire and maintain professional competence. Rule 3.5, a judicial officer must avoid the abuse of the power of issuing interim injunctions ex parte. You will notice that the said Justice bciheka flouted all these provisions of the Code of Conduct for Judicial Officers. It will further interest you, gentlemen, to note that this same Justice bciheka, sometime on 28th day of July 2021, delivered a judgment wherein, while sitting as a judge of the Imo State High Court, controversially declared one Honorable Chukwuma Umoji, who was not a party to the suit that was before him, as a candidate of the All Progressive Grand Alliance, ABGA, in the November 6, 2021 Guba election in Anambra State. While sitting in the Imo State High Court, he declared someone a candidate in another state. The person was not a party before him. How he came to know the name of the person he was declaring, today, till today, remains a mystery. Does his lordship even understand that there is something called jurisdiction of courts? In that suit, marked as HOW 543-2001, between one Chike Dike, INEC, ABGA, and Chief Jude Okeke, his lordship in paragraph 2G and 2H of the judgment order assumed jurisdiction over a case and determined a candidate for Anambra State governorship election. The Court of Appeal and Supreme Court have since decided on the issues of the candidates of the party in question. Again, we ask, how do these cases, these controversial cases, arrive at the desk of Justice IHEKA? Do litigants discuss with him before filing their cases with guarantee that it will arrive on his table, or is it by coincidence that they get to him? On the other hand, because of the questions we just asked, we believe that the Chief Judge of Imo State, Honorable Justice T.E. Chukwuemeka Chikeka, has some questions to answer to the NJC in the whole transaction connected to this case. She ought to be aware that Honorable Justice B.C. IHEKA is on election duty and has already been sworn in as a member of the 2023 Election Petition Tribunal, and still went ahead to assign election matter to him, where time is of essence. She saw the subject matter of the suit and still assigned it to a judge when she is aware that Imo State High Court has no jurisdiction and that the judge in question would not be available. Honorable Justice bciheka claimed to have sent the said file to Honorable Justice T.E. Chukwuemeka until this morning, the 19th of April 2023, the file cannot be found. We believe that Honorable Justice T.E. Chukwuemeka has failed in her administrative duty as a judicial officer and chief judge of a state. The injustice ensuing from the said actions of Honorable Justice bciheka and Honorable Justice T.E. Chukwuemeka is such that the people of Isu, Njaba, Nkwere, Wangele Federal Constituency will for a long time be without a member representing them in the Federal House of Representatives. The tall order made in the ex parte order is such that INEC is hamstrung and cannot do anything about the issue. INEC, note, was not a party in the suit, but the order was made against INEC, and INEC was not heard. Gentlemen, if things like this are allowed to stay unchallenged, the perpetrators walk away without consequences, it will serve as a booster for other merchants of anarchy to continue to flagrantly violate our electoral laws and processes on the fame of the ill belief that nothing will happen. Nigerians woke up and saw what happened in Adamawa State, where a resident electoral commissioner declared someone as elected to be the governor of Adamawa State without knowing that he did not have powers, he did not have any result sheet. But because people had done similar things and walked away free, people now have the impunity, the effrontery to take actions that they know are unlawful and unconstitutional and capable of throwing Nigeria into crisis. Notwithstanding these unfortunate happenings, we still believe that the judiciary is the last hope of the common man, and its image is currently at stake here. The integrity, fairness, and justness of the judiciary must be protected and sustained. Individuals, no matter how highly placed, must not be allowed to destroy the sanctity of the institutions of the judiciary. Let Honorable Justice bciheka and Honorable Justice T.E. Chukwuemeka be made to dance to the music they are playing. Thank you, gentlemen, and may God bless Nigeria. State High Court, you don't have jurisdiction. It's an election matter ongoing for a federal institution. You did not join the appropriate parties or the proper parties that were to be joined. INEC was not joined as a party in that suit. Now, the file is missing so that no action can be taken on that matter further. So, NJC should just, what we are requesting is, NJC, look into the rule books. What is the punishment for any person, any judicial officer that has done any such thing? However, we do not want, like in the case of Adamawa, where we just heard that the Inspector General of Police has redeployed the CP that perpetrated the treason that happened there. We do not just want such administrative parts on the back of the hand. We don't want that. We want stiff punishment according to the rule books so that it will serve as deterrent for any such other judicial officers that may be having in mind that there is something to benefit or profit from doing political vanvum.